This is Democracy Watch. Mark, this is the day we've been waiting for. You and I have spoken for months about this Louisiana lawsuit coming in front of the Supreme Court that will determine whether or not Section 2 of the Voting Rights Act remains intact or not. So I got to ask first and foremost, how did arguments go? And is there any indication that might suggest which way the Supreme Court justices might be leaning here?
Yeah, so with the caveat that you never know how a Supreme Court decision is going to actually come out because, there's time between now and when it's issued and the justices talk to each other and they exchange drafts. With that throat clearing, I would say it was a tough day for the pro-voting camp in the Supreme Court. You start with the assumption that there are three justices for upholding the Voting Rights Act. And there are three justices who have expressed in the past that they either think it should be overturned entirely or severely curtailed. So that leaves you, for purposes of our discussion, with Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett. And almost out of the gate, there were indications from all three of them, kind of on different lines, that they were deeply skeptical that the current way in which Section 2 of the Voting Rights Act, which is what's at issue, is interpreted and enforced, should be the way it is going forward. So look, I'm not going to say all hope is lost, but I think we need to be clear-eyed about where we are going from here.
Mark, did you hear anything from those justices, though, that might suggest that they'd be open to erring on the side of these liberal justices? Was there any hope that you can take from the tea leaves here?
Yeah, there were some. I mean, look, in the course of these arguments, you hear a variety of advocates make their oral presentation and the justices ask questions. So you're reading the tea leaves based on that. And among the skepticism about the Voting Rights Act were sort of two things that you could take as not entirely negative. The first is there was a discussion of for how long should race-based remedies be allowed. Now, the short answer to that is they should be allowed for as long as they're necessary to remedy discrimination in voting. And that's not a reason to strike down a law that Congress not only passed in 1965, but has reauthorized over and over again. And if it is to be repealed or modified, that is really something Congress should do, not something the court should do. So there's an answer to that. But there was some recognition, though, in that question of how long that sort of springing this on the political system in the beginning of 2026, which would be the earliest the decision could come out, might be practically quite disruptive. And so it is conceivable that the Voting Rights Act sort of lives to fight another day with some cautionary language about what will happen down the road. So that was, when that's what I'm offering as optimism, gives you some sense of how I felt the argument went. But that was one thing. The second is that it's not clear that the justices on the conservative side have a coherent or an agreed upon framework of what should come next. And the reason why this is important is that sometimes they will actually punt on a case. They won't do the bad thing because they are waiting for a vehicle in which they can coalesce around what the right outcome is. And there was some of that struggling going on here. Now, were there sufficient camps of people that you could wind up with a fractured opinion, but nevertheless a bad outcome? Yes. But it wouldn't be totally shocking to me if the justices just decided to kind of deal with this case, maybe reverse, maybe not, but on very, very technical grounds or very, very limited grounds, so that they can sort of take another big swing at this sometime in the future when they feel like they are more they have a better handle of what comes next. Because look, Section 2 of the Voting Rights Act has been on the books for a very long time. It is actively used. And, the current test for whether there's a violation of it for redistricting goes all the way back to the mid-1980s. So they can't break it without having something else in place. And so there was some, I did sense some uneasiness from the justices along with that sort of suddenness concern that maybe would cause them to go slow. But overall, if you ask me where I think we stand in a world in which the Voting Rights Act, if not entirely struck down, Section 2, I think it is going to be rendered with much less teeth, far fewer teeth, and really open the door for Republican legislatures in the Deep South to do some pretty horrific things.
So that's what I want to talk about right now. But first, just a quick reminder for folks who want to continue to read and learn more about this. Mark has been doing an amazing job covering this issue on Democracy Docket, which is his news outlet that he uses to focus on everything voting in elections. If you're not yet signed up, please do yourself a favor. You'll not only get an excellent resource, but you'll support the invaluable work that his team is doing, not just in the media space, but also on the front lines in the courts where it matters most. So I'm going to put that link on this screen and also in the post description of this video. Mark, to that exact point, can you speak a little bit about what the practical effects would be if indeed the Supreme Court does strike down Section 2 of the Voting Rights Act? What would it look like in practice here?
Yeah, so let's break those into two parts. What would it mean for minority voting rights? It would be quite catastrophic, right? It would undermine the principal federal law that has been used for the last generation plus to protect against discrimination in voting. Okay, so like the Voting Rights Act Section 2 has nationwide application. It doesn't only apply in certain states. It also applies to all kinds of voting laws, not just redistricting. So, in some sense, Section 5 of the Voting Rights Act, when it was struck down, it garnered a lot of attention, but Section 5 only covered certain jurisdictions in certain states. This would have much broader application. In partisan terms, this would be an absolute calamity, particularly if it happens in 2026. I mean, the one analysis that I saw, which I tend to agree with, is that it could allow for 18 or so seats that are currently held by Democrats as a result of being the minority candidate of choice, that those would immediately become vulnerable to be redrawn mid-cycle. In other words, when you take the map and say, where do these seats exist? Where do Republicans control the process and could do mid-cycle redrawing? I think that 18 is probably a fair number. The New York Times used a more restrictive analysis, but they came up with 12. But let's be clear, whether it is 12 or it's 18 or it is something in the high 20s, which is, I think, where it eventually would creep to, after that kind of low-hanging fruit, it will have dramatic partisan consequences, particularly if this is allowed to happen in 2026.
Now, looking at the flip side of that, obviously, to your point, it would be calamitous, not just for these individual states, but democracy more broadly. But as a way to push back against this, would this also kind of unshackle blue states to be able to do the same thing in an effort to counteract? Like, blue states are also bound by Section 2 of the Voting Rights Act. Would this kind of unshackle them to be able to go ahead and redraw their maps mid-cycle to counteract what the Republicans are doing in their states?
I mean, yes and no. I mean, this is like a conversation you and I keep having. And I am from the camp that says the Democrats already have this power and already should be doing more in a number of blue states. And you have been a real leader on this. If anyone wants to see, go look at the interviews that Brian has done with any number of governors of blue states. And he always asks them this question. He always asks them, and not just the Gavin Newsoms, but also, literally blue state governors across and candidates for blue states. So go ahead and subscribe to this channel, which is the most important way to stay informed about this, but also check out some of those videos. But as you know, you and I have kind of been like beating this drum that Democrats already should be doing this. But yes, sure. This would give another sort of legal tool or lack of protection that would allow Democratic states or blue states to redraw more maps. But, that starts with the political will on the part of those states to do so.
And do you think that Democratic governors right now are doing enough on that front, even in advance of what may or may not happen with Section 2 of the Voting Rights Act, but are doing enough to counteract the moves that Republicans are already making with these mid-cycle redraws?
I don't. I mean, look, again, you can go back and I don't even know which one it was where, I first said I thought Democrats should redistrict 30 districts.
Yep.
Throughout the country. And I think if Democrats had done that when Texas first popped up its head on this, you might have seen Republicans essentially sue for peace and be like, look, you don't do that, we won't go further. You do California, we do Texas, and we call it a draw. But instead, what we've watched is, Republicans move forward now in Missouri. We see Republicans moving forward in North Carolina. Republicans appear that they may move forward in Indiana and Kansas. And of course, Florida is for sure going to move forward. Ron DeSantis is not going to miss out on this party.
Yeah.
And we may see other Republican states that I didn't just list now. Particularly if the Voting Rights Act falls, you're going to see some of those states in the Deep South move forward. So I think that there is, I think that every Democratic governor, every Democratic legislature ought to be asking itself in this time of great need, at this time when democracy is on the line, at this time when literally the outcome of the 2026 elections could be the difference between whether we have a functioning democracy going forward or we don't. Because if Donald Trump has complete control of Congress for 2 more years after 2026, and Democrats are locked out at the federal level, it's going to be, it's not going to get easier in 2028, right? In 2028, it's going to be that much harder to combat all of the damage that Donald Trump has done, not just to this country, but to the idea of democracy and free and fair elections.
So let's talk about when the Supreme Court could rule on this question and what the implications would be if they rule early versus if they rule late. So what are our options here?
Yeah, so I think we ought to look at 2 windows. One is mid to late January. So essentially think of that as, after the new year, not the week after New Year's, but maybe the week after that till through the end of January. And that's kind of window number one. That is the window that the state of Louisiana has asked the Supreme Court to meet. Because after all, Louisiana wants to redraw its maps in time for 2026. Right. And so it is saying, Supreme Court, if you're going to rule, please rule very quickly. And
did they say anything about that? Did they respond? Was that something? Was there anything that the justices said in response to that request, or
no?
Was that just like a written
that request
request
was made as part of the briefing. Okay. It did not elicit any real back and forth of the oral argument today, and the justices have not spoken to it. So that's window one. Window two is the traditional end of June window, right? So if this was not an election year, if we were not in the wave of mid-cycle redistricting, and that was all the fad among Donald Trump putting pressure on Republican legislatures, then I'd be saying, look, the most likely outcome is a decision sometime end of May or else in June, because this is one of the big cases of the term. And usually the big cases of the term get decided at the end of the term, right? So that's why you always get this big rush of decisions, in June before they leave, before July 4th. So I think those are like our 2 options. We're either going to try to meet that deadline or they'll just put it on the regular track. If you ask me my opinion, I'd say they're going to meet the deadline. I think that they heard this case last term. They ordered it re-argued for a reason. They kind of know where they want to go. They scheduled the oral argument for among the first cases to be heard this term, right? The term literally just started in the beginning of October, and here we are. The case has already been heard. And so I think they are going to move a decision out really quickly. Now, the only precedent I can go by, which is, not much precedent, was Citizens United was argued in the spring, or was argued for the decision in the spring of 2009. At the end of the term in 2009, the Supreme Court held it over, said they wanted it re-argued. It was re-argued at the end of September of 2009 rather, and a decision came by January 10th. 2010. So I think that, maybe, this was argued a couple of weeks later. So maybe we're looking at the end of January.
Okay. Which I guess raises the big question here, which is, let's skip ahead and assume that the worst happens, which is that not only do the justices rule in favor of Louisiana, but they do so in January and basically clear the runway for Republicans to be able to engage in these mid-cycle redraws. And we see, 20 seats get flipped or redrawn so that they would be much easier for Republicans to win. When the deck is stacked so heavily against the Democratic Party, when they have basically scientifically engineered an outcome so that they can preserve control of the House, where do Democrats go from there? How do you what comes next? What do you recommend? What do you say to people who say, how do you even engage in democracy when democracy isn't happening on one side? And in fact, the rules of the game are such that there is no way for the left to win anymore.
Yeah. So I'd say 2 things. The first is that in the short term, we need to be moving fast and aggressively on every front that we possibly can for 2026. And that means encouraging our Democratic elected officials in states to consider reconsider whether they can do redraws. Hopefully you'll do another round of interviews with all those governors and you'll ask them.
Absolutely.
And so I think that we can't stop on that front. The second is, I can promise you lawyers like me will be in court. We will be challenging what Republicans are doing on any grounds that there are to challenge them. And there will remain some grounds that are not covered by the Voting Rights Act. So there are other theories by which districts can be struck down. And I've in fact
the state constitutions, for example.
Yeah, exactly. For example, as a racial gerrymander under the U.S. Constitution. I've argued and won 4 cases in the Supreme Court arguing that. There are state restrictions, state constitutional restrictions that may be able to be made. And so people can't give up hope that we and just stop, right? We have to work that much harder. And also we have to make sure we are turning out voters and dealing with all the rest of voter suppression. In the long run, look, I have now published on Democracy Docket. I've done videos on my own channel. And you and I have talked about this on this channel, about what I call building a new democratic opposition. And I talk about this in terms of an opposition rather than a resistance, because an opposition needs to have a much longer time horizon. Now, I don't know whether that time horizon is 2028, 2032, 2036, 2042. I don't know what that long range is, but I do think that we as Democrats and as progressives, we have to both be able to fight the fights in front of us. We have to be able to deal with and triage the immediate challenges. But we also need to put a lot more energy than we currently put into thinking, okay, what is the thing we want next? And I don't mean this in the glib way that people say you can't just be against Donald Trump, you have to be for something. I'm actually saying something different, which is that the Department of Justice, for example, it has been thoroughly politicized. We are never going back to the days of Merrick Garland's style of the Department of Justice. And so whether you thought that was a good style or you thought it was too passive or whatever, we're not going back to that. What's going to happen is going to be something different. And so Democrats and progressives need to be using this time to figure out not what Donald Trump is doing wrong, but what do we want this to look like? What do we think the executive branch should look like after Donald Trump? What do we think that the relationship between the federal government and governors over the National Guard should be going forward? What do we think voting rights and procedural democracy should be? And here's the thing. I was a huge supporter of the Freedom to Vote Act and the For the People Act and all of those bills that came before. But if we think we're just going to dust off those things if Democrats take control, and even if they have the votes in Congress, then we're missing the real opportunity, which is to figure out what does the world look like? What do we want the world to look like after Donald Trump? That is not just saying going back to what was before.
All right. Well, look, I know that we are going to stay on top of this issue. Again, you have been an absolute leader in terms of your reporting on this. So highly recommend for anybody who's watching right now. If you're not yet signed up for Democracy Docket, go ahead and sign up. I'm going to put that link right here on the screen and also in the post description of this video. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.